Ready? Start. The defendant denied the plaintiff allegations. Stop. The defendant denied having taken any loan or having executed pro note or receipt. Stop. The defendant alleged that the plaintiff and the defendant had jointly purchased a tractor and later on the defendant paid the total amount of the tractor to the plaintiff by settlement and the matter was resolved. Stop. The plaintiff might have fabricated thumb impressions of the defendant on papers. Stop. Various other pleas were also raised. Stop. Both the courts below have come to concurrent finding that defendant borrowed rupees 35,000 from the plaintiff and executed pro note and receipt for the same, but failed to pay the said amount with interest. Stop. The said finding is based on proper appreciation of evidence and is not shown to be perverse or illegal. Stop. Learned counsel for the appellant, however, contended that the pro note is unstamped and therefore no decree could be passed on the basis of unstamped pro note. Stop. Reliance in support of this contention has been placed on judgment of this court in the case of firm Gobindram and Company, Yamunanagar versus Sita Devi alias Sita Rani, reported as 1976. Stop. On the other hand, learned counsel for plaintiff respondent contended that pro note was admitted in evidence without any objection from the defendant regarding the pro note being unstamped and therefore in view of section 36 of the Indian Stamp Act 1899, admissibility of the pro note in evidence cannot now be called in question. Stop. I have carefully considered the rival contentions. Stop. It is correct that pro note is unstamped. Stop. It does not bear any revenue stamp, although receipt bears proper revenue stamp. Stop. However, if defendant had taken objection to the admissibility of the pro note in evidence on the ground of being unstamped, then no decree on the basis of unstamped pro note could be passed. Stop. The defendant, however, did not take any such objection when the pro note was admitted in evidence. Stop. In fact, in trial court, no such objection was raised at any stage. Stop. In view of section 36 of the Act, admissibility of the pro note in evidence cannot be called in question at appellate stage when no objection to its admissibility on the ground of being unstamped was raised when the pro note was admitted in evidence. Stop. Language of section 36 of the Act is very unambiguous and admits of no two interpretations. Stop. In view of said mandatory provision, the contention now being raised by counsel for the defendant appellant cannot be accepted. Stop. Over.